Welcome. My name is Jonathan Harwell-Dye, and I'm the Director of Programs for the Arts and Business Council of Greater Nashville. We are an independent 501c3 nonprofit that leverages and unites the unique resources of the arts and business communities to create a thriving, sustainable, creative culture in Nashville. We do this by providing education, resources, and opportunities to the creative community while connecting the business community to the arts to foster workplace creativity and innovation. When you become a member of the Arts and Business Council, you join artists, art lovers, creative organizations, and leading Nashville area companies in cultivating our creative community. ABC's flagship program is the Volunteer Lawyers and Professionals for the Arts, which is a referral service providing pro bono legal services to income-qualified artists, arts organizations, and creative businesses in Tennessee. VLPA services include our monthly Black-owned small business and nonprofit legal clinic with our partners at the Bradley Law Firm. Tennessee small businesses that are at least 51% Black-owned with less than $1 million of annual revenue are eligible. The September clinic is almost full, but there are still appointments available. And with that, I'm excited to turn the session over to today's speakers, Monica McCabe, Copyright Claims Officer, Whitney Levandusky, Supervisory Copyright Claims Attorney, and Laura Kaiser, Copyright Claims Board Paralegal from the Copyright Claims Board. Welcome, all three of you, and thank you so much for taking the time to be here with us today. I'll let you take over from here.
Great, thank you. And thank you so much to the Arts and Business Council of Greater Nashville for hosting us today. We're really excited to be able to come here and talk about copyright law, the Copyright Claims Board, and how we work to resolve copyright disputes outside of the federal court system. So my name, again, is Whitney Levandusky. I will be starting us off with some framework, some basic copyright law concepts that we use every day in our operations at the CCB. So I'll also very start, tell you a little bit about our team. So the Copyright Claims Board consists of 8 staff members. So 3 of us are here today. We have 3 copyright claims officers, David Carson, Monica McCabe, who's on our panel today, and Brad Newberg. The copyright claims officers are in charge of managing proceedings, conducting proceedings, making determinations. Monica is our ADR, Alternative Dispute Resolution expert. So we are here to facilitate the resolution of disputes between copyright owners and copyright users. For the Copyright Claims Board staff, we have 3 copyright claims attorneys, myself, Dan Booth, and Maya Burchett. And we are here to provide authoritative legal information. We conduct compliance review, so review of claims, and we talk to claimants and respondents and participants about copyright law and the Copyright Claims Board proceedings. And then we have our paralegal, Laura Kaiser. She is in charge of our docket management and our pro bono and outreach opportunities. And then we have our program specialist, Natalie Cronin. We'll talk a little bit more about our frontline resources for asking questions. If you have a question for us about CCB procedures, Natalie will be your frontline person helping you and assisting you with any sort of CCB question that you might have. So let's talk about some core principles of copyright. We are, as the Copyright Claims Board, we are authorized to resolve copyright infringement, non-infringement, and misrepresentation disputes. So when we talk about those types of disputes, here's the law that underpins them. Just a step back, you know, copyright is part of a larger ecosystem of intellectual property in the United States. We generally think of 3 types of federal trademark law. We think of trademark, patent, and copyright. Now, each of these systems they have different eligibility criteria. They protect different things and for different amounts of time, and you take different actions to secure that IP protection. So it's important for anyone out there. I saw that there's an advertisement for small business support Nashville area, or if you are a creator who has sort of a business arm, it's important to kind of think about intellectual property separately. So trademark is a legal system that protects the identification of goods and the source of goods and services. Patent is a system of protection that protects new and inventive ideas. And then copyright is a system of protection that protects original creative expression fixed in a tangible form. And this comes and sort of relates to us and our work on a regular basis, because we do have people who come to us with disputes of the trademark variety in particular, that we are unable to help or assist with because we are a copyright exclusive board. Next slide. So know that when we're talking about copyright, we're talking about federal law. We are talking about the Constitution. Everything that we do within the copyright realm goes back to Article 1, Section 8, Clause 8, which gives Congress the authority to promote the progress of science by securing for limited times to authors the exclusive rights to the respective writings. Congress has taken that authority and power, and over a number of centuries, created and developed copyright law, including the Copyright Claims Board. So whenever you're thinking about copyright law, you're thinking about the Copyright Act within Title 17. If there's anything, if you ever kind of need sort of clarification about what is protected by copyright, know that you just need 3 things for copyright protection. You need an original work of authorship fixed in a tangible medium of expression. Once you have those 3 things all together, you have copyright protection. Copyright protection does not require registration. It does not require an affirmative act. Once you have that original work of authorship that's fixed, you have copyright protection. Now, the state law used to be play a much bigger part in copyright. And if you ever have any questions about, say, pre-1972 sound recordings, that's something that's definitely outside of our purview, but you can always ask the Copyright Office, and they can provide more information about things that might relate to state law. So originality, right? So this is the buzzword within copyright. What do we mean when we say originality? We mean 2 qualities. We mean independent creation and sufficient creativity. And know that when we talk about originality and we talk about creativity, we mean something specifically within the legal world. So independent creation means it's not copied. You created it yourself. For sufficient creativity, you just need a modicum. They say that the bar is low, but it does exist, right? So once you have a minimum degree of creativity, you have copyright protection. And this can be a little bit different than what we think about when we describe something as creative, right? When we describe something as creative, we might mean, wow, it's genius, it's brilliant, it's beautiful. For copyright protection, for copyright purposes, sufficient creativity means just a little bit of expression that is owed to the author, and that sort of reflects their own sort of ingenuity. Now, the bar is low. We just need that minimum degree of creativity, but it does exist. So there are certain things that we say are categorically not protected by copyright. Words and short phrases, blank forms, typefaces, general layout, and things like useful articles. So we'll talk a little bit more about how you bring a claim or you respond to a claim at the Copyright Claims Board, but know that registration, that sort of recognition that the work is protected by copyright, is an important first step. And so when you seek copyright registration for a work, if you are seeking copyright registration for a word or a short phrase or a general layout, know that that there might be issues where the CCB might not be the jurisdiction for you. So you have copyright protection, right? You've got that original work of authorship, fixed and tangible medium of expression. What does that mean? That means that you are given a bundle of rights. You're given a collection of things that you can do, or you can authorize other people to do. You can reproduce the work, you can adapt or create a derivative work, you can distribute the work, you can publicly perform it, and you can publicly display it. Now, these rights, they last for a limited time. They do last for the life plus 70 years, and this is for works that are created today. Life plus 70 years. There are exceptions to this rule. If you have a work made for hire or an anonymous or pseudonymous work, then the term of protection is the lesser of 95 years of publication or 120 years from creation.
I just wanted to make it one clarifying point. When we say life, we mean the life of the author.
Yes.
So it's the life of the author plus 70 years.
Yes. And even to add a little bit more, when you have a joint work saying that you have multiple authors, the term of protection is going to be the life of the last surviving author. Next slide. So when we think about copyright, copyright protects, again, any sort of work that's fixed in a tangible medium of expression. So usually sometimes when I do these presentations, I'll ask if anybody in the audience is a copyright owner, and the answer is always yes, right? If you take photographs on your phone, you're a copyright owner. But we also think about copyright as supporting core copyright industries within the United States. We have the literature, the publishing industry, the music industry, music, software, movies, newspapers and journalism, photography, and the like. So today I'm just going to speak a little bit about some highlights within the music industry. So in 2021, we were looking at 15 billion of retail, with 83% of that revenue from streaming. That's a radical change, right? Over the last 10 to 20 years, where the increase of streaming as a revenue stream is, has radically changed the landscape for the music industry. And when we think about copyrighted material of music, we've got, you want to think about this kind of unique distinction, right? You're listening to one piece of you're listening to one audio track, but you're experiencing two copyright protected works, right? You are listening to the you're listening to the musical composition, which is the music and lyrics, and then you're listening to the sound recording, which is the production, the performance. So this creates a unique landscape that is supported by contracts and agreements among different types of parties. And this isn't even talking about all of the visual and audiovisual works, photographs, liner notes, that goes to support the core musical works and sound recordings that are distributed through the music industry. So next slide. When we're looking at, this is kind of a sample of types of claims that we've received at the Copyright Claims Board. And this is a sample of our overall landscape of copyright protected works. So for the Copyright Claims Board, we've seen claims within all categories of copyright protected works. And you see that musical works and sound recordings comprise a good percentage of the claims and disputes that we receive. We receive 40% of pictorial graphic sculptural work. That can encompass things like photographs, but it also encompasses graphic design. Then we have a good portion for motion pictures, 19%. And then we have the next big tranche is musical works at 18%. So when we say a work of authorship, so I mentioned that we have those three qualities for copyright protection. When we say a work of authorship, we mean one of these categories here on screen. We think about, pictorial works as being, maybe photographs or fine art, but then it's also graphic design. Literature works can encompass both traditionally published news articles or books, but then they could also encompass things like procedural manuals or advertising copy. So when we think about the wide world of copyright, we're thinking about a wide world of expression. And I think we'll probably speak more as we go along about the variety of claims that we've received at the Copyright Claims Board. So with that, I'm going to pass it over to Monica, and she'll tell us all about the Copyright Claims Board and how it operates.
Thanks, Whitney. Good afternoon, everyone. Thank you for joining. I wanted to explain why we're here, why we're talking about the Copyright Claims Board, or the CCB as we call it. In the past, there have been issues with smaller copyright owners enforcing their rights. Part of the problem was that few attorneys are willing to handle small claims because they're not a great value, and oftentimes the legal fees can be quite expensive, especially in federal court. And so small owners felt like enforcement was not worth pursuing, unfortunately. And the accused parties felt pressured sometimes into settlement because they didn't want to pay the legal fees either. And often judges in small courts don't have a lot of experience with copyright, and jury, if you have a jury trial, can be very unpredictable. Next slide, please. And so it's been quite a history in trying to bring the Copyright Claims Board to be. There were certain groups like the Songwriters Guild that were pushing for some small claims copyright type tribunal to solve some of these problems I just talked about. And the process began in 2006, where there was a hearing involving small claims and orphan works. And Congress then asked the Copyright Office for a study, which the Copyright then released a report in 2013. And then finally, 2016, a bill was introduced into the House, several bills actually. They did not pass, again, introduced in 2019. And then ironically, with the COVID Relief Act, it was slipped in with that, and the Copyright Claims or the CASE Act came to be in December of 2020. We, Copyright Office and all of the staff here, spent a lot of time setting everything up and creating regulations and our website, as well as our online docketing and management system that Laura will talk about later. And so we finally were able to open and launch and accept claims beginning in June of 2022. And as Whitney briefly mentioned, there are only three kinds of claims that we can accept. One is copyright infringement. The other one is a declaration of non-infringement, which is an instance where someone is accused of infringing, and they ask us to determine that they are not infringing, because let's say they want to, publish a painting, and someone's accusing them that it was copied from their work. They can ask us to declare that they are in fact the owner of, and they're not infringing of that work. There's also misrepresentation claims. These are very specific misrepresentation claims. Sometimes we get general ones. It has to do with Section 512F of the Copyright Act. So it involves misrepresentation in a takedown notice or a counter notice for an online work. So a lot of people probably familiar with the DMCA, where something is infringing and you write to the online service provider and say, take this down because it's infringing my work. And we'll talk more about that later. And all the legal and equitable defenses that you can use in federal court, including fair use, can be applied before the Copyright Claims Board. So as Whitney mentioned before, copyright infringement is a violation of any of the exclusive rights. So for example, making or distributing copies of a sound recording that's not yours could be considered copyright infringement. In order to bring a copyright infringement claim, you have to show that you own the work, and often the best way to do that is with a registration, that the defendant copied the work, and that somehow the plaintiff, the infringed party, was damaged by that infringement. The statute of limitations for copyright infringement is 3 years. And different jurisdictions measure that 3 years differently. Sometimes it's from the first act of infringement, and in some places it's from the time you discovered the infringement. So it can get complicated, but in general, it's a 3-year statute that after that period of time, you often can't bring a claim. And this is just a graphic explaining what kinds of cases we've gotten so far. So we have about over 550 claims, and most of them are infringement claims, as you can see. There's 457 just straight infringement claims, and then if you include all of the other ones, it comes to 493. There are about 56 misrepresentation claims, but in the Venn diagram, you can see where there's some people bring multiple claims. And then we have fewer non-infringement claims. The section in the middle, which is 4, is the person checked all 3 boxes for all 3 types of claims. And this is a diagram showing how a case moves through the compliance process. So initially, the claimant files a claim on ECCB, which Laura will talk about later, which is our docket managing system. And then it's reviewed by the CCB attorneys to see if it's compliant. Is it a copyright claim? Is it a misrepresentation claim? If they find that the claim is not compliant, the claimant has 30 days to amend their claim, and we send an order explaining what needs to be fixed in it. If the claim is found compliant, then it moves on, and the claimant is given 90 days to serve the other side, which means formally give all the papers to the other side, and then they have to file the proof of service. If on the second one, the rectangle, the white rectangle up there, if it's still not found compliant after the second round, the party has 30 more days to fix it, and we will issue another order explaining what's wrong. And then, basically 3 strikes, you're out. If on the 3rd attempt you don't fix all the issues, then we dismiss the claim without prejudice, which means that it can be brought again, but you'll have to start the whole process all over again. So going back to the top row, the service, the respondent is given the papers, and then the respondent has a choice, because we're a voluntary tribunal, meaning the respondent can do nothing, and then the claim becomes what we call an active claim and moves on in the process. Or the respondent can opt out. They can say, nope, I don't want to participate before the Copyright Claims Board. I'm going to check this box, and I'm going to get out of this. And then the claimant still has the opportunity to bring the claim in federal court if they want to. But the respondent does have that option to not participate, and they have 60 days to file their opt-out form. Next slide. And this just shows you what happens after the claim becomes active, which means the respondent didn't opt out. So the respondent files a response to the claim, and they can bring a counterclaim as well. There is limited discovery that takes place where the parties exchange documents and information. Then they submit written testimony with evidence and a statement, witness statements. And then there is a virtual hearing. It's optional. If the parties want to have it, or if the board feels like it would be helpful, then a hearing will be held. And then finally, we issue a determination. I should say that all of our proceedings are done virtually. No one has to travel anywhere. We do them all on Zoom, which is very convenient for most people. Settlement can be accomplished at any point. We facilitate settlement conferences. We've held a number of them, and have been successful in helping the parties resolve their dispute. And there's a lot of safeguards, more so than in federal court, against defaults, where one party doesn't participate or fails to respond at all. Next slide, please. So this just shows you currently where we are at the CCB. We have 72 total active phase cases in active phase over time. Currently, we have 53 of those. We have 29 where responses have been filed, and 4 are where people are starting to submit their written testimony, their witness statements and their evidence. We have a number, unfortunately, in default, where we send several notices out, and 27 parties have received a first default notice. And then 4 have now moved on to the testimony phase, where we basically decide the case without the respondent being present. So we would argue or set forth if there are any defenses, even though the respondent is not there. And in terms of settlement, we've held 5 conferences, we've reached 3 agreements, and we have one coming up soon. And so we've tried to simplify the whole discovery process, which is often complicated in federal court. We have standard interrogatories and document requests, meaning everybody answers the same questions. They're in a fillable form. You could just fill out the answers and file it. And that's a limited number, but if you think you need more discovery, you can ask for it. It has to be specific. Those are not always granted. There's no depositions before the CCB. We do not have the power to issue third-party subpoenas, so anybody that testifies has to testify voluntarily. And a request for expert testimony is rarely granted, but the only case where we've granted is a very complicated technical case where an expert might be needed. And the other important thing to know about CCB is we have caps on the monetary awards that can be given. So the monetary award in any case can't exceed $30,000. We also have smaller claims proceedings, where the maximum is reduced to $5,000. I'll talk a little bit more about those in a minute. For claims with infringement allegations, the claimant can get actual damages, their actual damages, plus the infringer's profits that are attributable, caused by the infringement. Or you can ask for statutory damages, which are damages which are set by law. And before the CCB, those amounts are different than they are in federal court. So for a work that's timely registered, you can get $15,000 per work. If it's not timely registered, you get $7,500 per work. Another big difference with before the CCB is that you don't have to have the registration in hand before you file. In federal court, you have to have the registration before you can bring a claim or a complaint. Here, as long as it's pending, as long as you filed an application, you can bring your claim before the CCB. And this is what I was talking about before, the smaller claims track. Again, the damages are limited to $5,000. It's a much more streamlined track. There's very little discovery, and only one copyright claims officer will make the decision in those cases. In all other cases, it'll be 3 copyright claims officers, unless one of them recuses themselves for a conflict of interest or something like that. There are more conferences between the parties and the copyright claims officers in the smaller claims. And as I said, if there's a default by the respondent in smaller claims, then all three officers will be involved in the decision. And this just shows you how many standard track and how many smaller claims proceedings that we have. So there is 42% of smaller claims, which is the $5,000 monetary limit, and there's 58% are standard track claims so far. And when a respondent is deciding, should I opt out, should I get out of this, or should I proceed? Some of the benefits of being before the CCB, if you are a respondent or a defendant, is that your damages are limited. In federal court, you can get up to $150,000 in actual damages if willfulness is shown. We do not look at whether the infringement was willful or not willful. That under the Case Act, we're not permitted to do that. But that is an inquiry that federal court judges will look at. There's lower costs because we have streamlined procedures. There's not, a lot of discovery. You don't have to have a lawyer. You can file without a lawyer. Laura will talk more about how many people are doing that. There's a lower risk of a default because you get, several reminders, and we email it. We mail notices to everyone, and you get automatic notices if you're registered on ECCB. We also closely monitor bad faith actors. So if you've, a party abuses the system more than twice in a 12-month period, they'll be banned for a year from filing any more claims. Or they might be ordered to pay the other side's attorney's fees and costs. The findings are more consistent because there's only 3 of us. We all have a lot of copyright experience, I think over 90 years between the 3 of us, so that we're well versed in copyright law. And we're all impartial. We've both represented artists and users of copyright. I'm going to turn it over back to Whitney for a compliance review.
Sure. Thank you, Monica. So I'd just like to do a couple of highlights on, types of issues that we see when we conduct compliance review. Next. So some important things to highlight and to re-emphasize from our overview of the CCB procedure is that every claim or counterclaim goes through compliance review. This is a benefit of the CCB for both claimants and respondents. The CCB, we review the claim against copyright law and regulations, and the claim cannot proceed until the CCB finds the claim compliant. And as Monica showed us on that earlier slide, it's a cycle, right? We've got 30 days to fix, and then we've got 2 rounds of amendment. Next slide. And this is kind of the way that things have been going. So of the 550 claims in round 1, we see a balance of 325 non-compliant claims and 180 compliant claims. In round 2, then we have a much more even split, right? So now we have 74 non-compliant claims, 60 are found compliant. And then in round 3, an even more even split with 16 non-compliant, 15 compliant. Next slide.
I just want to say that there's been something put in the chat about CLE credit. So if you're an attorney, please check the chat.
And this is the big picture, right? So 255 claims have been found compliant during this compliance review process, and 187 have been dismissed. So we are looking at about 2/3 of our claims going through that compliance review process and moving on to service of process. So just this highlight of some of the common compliance issues we found. A lot of this goes back to the fundamental needs to establish a claim for infringement. So access and substantial similarity, showing that the 2 works are substantially similar, that there are some allegations that the infringing work wasn't independently created. Legal or beneficial ownership is an important part. We can only hear a claim from a legal or beneficial owner. So this is also another good point. If you happen to find yourself to be a small business owner, before you file a claim, make sure you check whether you or your business holds the copyright. And then registration, that's the prerequisite before you file. Before you file your claim, you at least have to have an application in. I've got a yellow button over on the right because one of the biggest things that we see in our claims involving music is needs to be clarification between whether the claimant is bringing a claim in the copyright of the musical work, the sound recording, or both. So this is a really great opportunity if you do decide to bring a claim with the CCB to either reach out to us before you file, to reach out to the ABC before you file, and make sure that you understand and you know whether or not you have the copyright in the music and the lyrics, in the performance, and what is the alleged infringing activity. Is it in that music, lyrics, performance, and production, or all of the above? And then, Monica mentioned that we often get misrepresentation claims for like general misrepresentations, like, oh, this person said something that wasn't right. Misrepresentation is very limited in our context. And so in compliance review, we do spend time helping people understand that misrepresentation is about copyright. It has to be a misrepresentation in a notice or a counter notice, and that the respondent is the party that sent the notice or counter notice, and that there was a harm due to that misrepresentation itself rather than the overall infringing activity. So let's turn it now over to Laura, who's going to talk to us about all of the ECCB and CCB resources.
Thanks, Whitney. So yeah, I'll just give you all an inside look into ECCB, our case filing and management system, some additional resources, and some final statistics if we have time. So when we set up the CCB, we also set up an electronic filing and case management system. You can check it out at dockets.ccb.gov. You do not need an account to search cases and see what we've been filing and what parties have been filing. It's a public website, publicly available. And this is also where you will register if you would like to engage with us, if you would like to file a claim, respond to a claim. If you're an attorney representing a client, you register in the same place. So this is your one-stop shop for all things CCB. We also set up a designated service agent database. So under the CASE Act, corporations, partnerships, unincorporated associations, they can elect to receive notices and service through a designated service agent. And that's available. There's a link for that on our website, ccb.gov. And the claimants are responsible for checking our designated service agent database and inputting that information when they file a claim if there's a designated service agent for one of the corporations. And that is also where that corporation will be served. So it's important to check it if you're bringing a claim. Don't confuse it with the DMCA database. We get a little bit of confusion sometimes, but we have our own. The CCB has its own designated service agent database. So just to give you a little bit of an inside look of ECCB, if you haven't yet poked around on there, this is what it looks like when you have an account, you've registered. This is what your dashboard will look like at the top. You see you have different options for starting a fresh claim. Maybe you've saved a claim in the system and you need to finish it. If you're responding to a claim, if you're amending a claim, maybe you've received an order of non-compliance from us and you need to amend. So it gives you all of those options once you log in to ECCB. And as we've mentioned before, we have the 3 types of claims that we can hear: claims for infringement, non-infringement, and misrepresentation. So when you're filing a claim, this is one of the first screens you'll see will be to select, what type of claim you're filing. Note that we do have these tooltips. That's the eye with the blue circle around it. You can hover over that for more information. Frequently, we link to very helpful resources, such as our handbook. So if you see terms or things that are confusing or you're not quite sure how it works, do check out our tooltips, because frequently they'll be able to answer your question. If you are responding to a claim, this is what the flow looks like for when you're in the response. It looks very similar to what the claim form looks like. You can provide your defenses. We've tried to make everything very streamlined and easy to understand and move through, so there's clearly outlined steps for you to follow. But of course, if you have any questions about how to use ECCB or what terms mean, you can always email us at Ask the Board, and we're happy to provide you with resources. And this is our opt-out form. As Monica mentioned, we are a voluntary tribunal, so respondents who would prefer not to have this case go forward with the CCB can easily opt out. You do not need an account to opt out. There is simply a button on the main page to opt out. No one needs to register to do this. You just fill out the form. Importantly, there is an opt-out key code that you will need to complete this. And that opt-out key code is going to be found in the packet that a respondent receives when they are served. So you need that for 4 letters or 4-digit code in order to opt out. If there's multiple respondents in a proceeding, they each have their own opt-out code. So just keep that in mind. If you have an entity and an individual, they're each going to have their own opt-out code. And you need to do then 2 forms to officially opt out for both of the respondents. And we have a very robust website with lots of resources that I believe a link was provided before this presentation. But we encourage people to poke around and check it out. We have a link to get to ECCB here, obviously to the Designated Service Agent database. We also have the link to our handbook on our main page. I think we have over 20 chapters at this point that each talk about a discrete area of our proceedings, you know, whether it's filing a claim, responding to a claim, what happens if people miss their deadlines. We have a whole chapter dedicated to service. So there, you know, everything is kind of broken down and should be easily understandable. It's a great place to start if you're unsure about a certain part of the process. And we also have our pro bono assistance page available through ccb.gov. This is where we are listing law school clinics and organizations such as the Arts and Business Council of Greater Nashville, great resources for our participants or potential participants to reach out and see if maybe there's a pro bono attorney available to assist them with filing a claim or responding to a claim, or even partway through a proceeding if need be. And we also have a few law clinics who have law students available to help as well. These are just some areas we've identified where we think having the guidance or help of an attorney might be useful to people. You know, with registration, the rules around that, as Monica mentioned, you just need to have the application on file to file a claim. You know, the decision of whether to file a smaller claim or not might be a particular decision point you might want assistance on. Deciding whether to opt out. Is the CCB a good space for you if you're a respondent? Would it be beneficial? That might be an area where you want to seek additional guidance. And then as we get farther into our proceedings, there will be stages where discovery needs to be exchanged between parties, where you have to prepare witness statements and evidence and written testimony. And even though we've really broken it down and tried to make it very straightforward, sometimes some of those stages where there's more writing and more gathering of documents involved, you might want a little assistance as well. So there's plenty of spaces to seek help if you need it, but we've also made the process easily usable without an attorney too. So this is our current breakdown as of late last month of who's filing claims before us. So we have a large number of self-represented parties. So they do not have an attorney with them. They're just coming to the CCB themselves. We also have 92 who have selected that they are in-house attorneys or authorized company representatives, for example, for a small business. So, you know, those two numbers together, the 318 and 92, are really a big chunk of our, what we would consider really like to be self-represented parties. And then we obviously have a bunch that have attorneys, outside counsel involved. And we do have a couple of law student representatives, but they are on the respondent side currently. So we have two cases where the respondents have a law clinic assisting them.
As I say, attorneys, check the chat again.
And I will just briefly go through a few last stats and then we'll turn it over to questions. So we have, we have over 550 claims as of late last month. So it's been pretty steady since we opened over a year ago. So we expect more to come. And then we have a number of reasons why cases are dismissed. So this kind of just breaks down a few different reasons why cases, you know, that we dismiss them off of our dockets. So if someone doesn't amend in time in compliance review, you know, 30 days to amend. If you don't amend in 30 days, we dismiss. If you have 90 days from when you receive a notice of compliance to serve the respondent as a claimant, and if the claimant doesn't file a proof of service in that time, we dismiss. You can request to withdraw the claim, of course. Some parties also settle the case and then they, you know, file with us a notice that they have settled and would like the case to be dismissed. So we were notified of settlement in 26 cases that we know of. The respondent opts out, obviously, we dismiss those cases. If a registration was refused or a registration file was closed. So because you can file with us without having a approved, registration in hand, we do have some cases where we're obligated to dismiss if the registration file is just closed out. And now that we are a year, more than a year in, more than a year and a half in, we have a few final determinations in a few different types. So we have a final determination in a contested case. If you'd like to see that case, the number is 22 CCB 0045. And you can look that up on ECCB. We have some defaults where we've issued proposed default determinations, and after 30 days, they become a final default determination. And then some final determinations are due to other things like settlements or a dismissal with prejudice if someone has requested to withdraw. So if you want to take a look at some of our determinations, you can do a document search on ECCB just for final determination, and you can read what the board has written in all of these cases. And we have claimants coming from a number of states and countries. This is representative of 43 states. So that's where our claimants are coming from. So just have a few more to get to the whole of the United States. And even though we can't hear cases against foreign respondents, our claimants can be international. So we have 26 countries represented so far. And with that, we want to open it up to questions. We know that was a lot of information, so take your time, but let us know if you have any questions. Thank you.
I see a question just came through. Jacob asked, what percentage of compliance complaints are dismissed due to respondent opting out? I saw the absolute numbers in the slide, but was having trouble doing the math quickly. So what percentage of compliance complaints are dismissed due to respondent opting out?
That is a tough number because, we've got the number of dismissals for opt-outs, which is, 43. So we know what the numerator is. And then the question is, what's the denominator, right? So we have the compliant claims that have gone through, that's like 255. Of those compliant claims, then we have to look at the certain number that have been served, which is a number I don't think that I quite have off the top of my head. So one of the things that we do kind of take a look at is we look at, the number of respondents who have opted out, and then we look at the number of like second filing fees, so the claims that have gone active. And I think that there we've had about, I want to say
73.
73.
Yeah.
73. So, if you want to think about it that way, you could take a look at, we have these 43 claims that were closed for opting out. We have 73 of these claims that were successfully served, and the opt-out period ended, and we went into that active phase.
And Whitney brings up a good point about the filing fees. We didn't talk about that. The filing fees before the CCB are very inexpensive compared to federal court. So in federal court, you're probably going to put out $350 to $400. Our initial filing fee is $40. If the claimant does not opt out, then you pay $60, and then the claim becomes active. But if the claimant opts out, you just pay that initial $40, and that's it. If it's an active case and it goes forward, the total that the claimant pays is $100.
Thank you. It looks like we have two more questions. The first is from Bonnie. Bonnie asks, can music copyright be held by an individual, or does it have to be held by a publishing company?
It can be held by an individual, or it can be held by a company. That would be a decision between the individual who maybe created the work and the publishing company who is going to distribute the work or exploit the work somehow. And sometimes I've seen splits between the individual and the publishing company. Sometimes the publishing company takes all of the ownership. So that's kind of a privately negotiated thing, and it often depends on who the publishing company is.
Thank you. All right, and our next question, Hillel Frankel asks, regarding claims for actual damages, is that also capped at $30,000?
Yes, actual damages are capped at $30,000. If you only have one work, and let's just say it was timely registered, the most, and you want statutory damages, the most you can get is $15,000. If you have 2 works in the same claim, and they're timely registered, the total you'll get is you could get, I should say, is $30,000. If you have 4 works timely registered, you're only going to get $30,000, even in statutory damages, if that makes sense.
Thank you. All right. Does anyone else have any questions they'd like to submit through the chat? Oh, hello. Had a follow-up question. What is required for service?
You want to take that?
Sure. So for service, this is a process that you would start after you receive a notice of compliance and direction to serve from us. So that document is posted on ECCB, and we give you all the instructions and all the materials that you need to serve the respondent or respondents in the case. So those packets need to be, you have to follow either the Case Act, which has its own rules for service. And all of this information also can be found in the handbook chapter on service. So you follow the Case Act, or you have to follow the law of the state where the respondent is for service. And unfortunately, the states have slightly different rules depending on which state you're serving in. So you do, a good place to check frequently is state court websites, because frequently they'll have help pages for people that are trying to effect service in their state. So you might want to check there and see if they can provide you some more information. But there are different rules depending on whether you're serving an individual or an entity. Be sure to check if they have a designated service agent or a registered agent for service. The Secretary of State website for each state usually has if you look up the company, they'll tell you if there's a registered agent, and then you have to serve that person at that address. You might consider hiring a process server. We have a lot of people that do that because the process servers in each state tend to be familiar with the rules. And then they'll prepare like an affidavit of service for you to file with us that, certifies who they served and when and gives the information. And then just be sure to file something with us within the 90 days of receiving that notice of compliance and direction to serve. Otherwise, we do dismiss the case. We don't have wiggle room on that 90 days. So even if you go and serve, you have to make sure you upload something with us so that we see that you've done it, it's been done. We have a form, a proof of service form that you can have the process server fill out, or you can fill out. You have to sign it under penalty of perjury and all of that. It's pretty straightforward. You don't have to use the form. Like if the process server gives you an affidavit of service, you can upload that. It just needs to have all the information that we need, and we do check for that. Another option is to ask the respondent to waive service. So that's another method. You can say, are you willing to waive service in this case? There's a separate form for them to just fill out and return to you. That also needs to be uploaded to ECCB. So if you get the waiver of service back from them, within a month or so, great, upload that. They've signed off. They don't need formal service of process. They will get an extra 30 days to file their response if they do that. So there's some incentive for them to waive service in those cases. But if you don't get that waiver of service back in about 30 days or so, you might want to start thinking about formal service, because then obviously you only have a couple months left to do it. So yeah, definitely check out the service handbook chapter. You can email us if you have questions about process and procedure. We can't provide legal advice for it, but we have a few resources we can help point you to. So hope that starts to answer the question.
The one thing I would just say for the non-lawyers is a lot of people think you can just put it in the mail. And, a lot of states do not permit service by just regular mail without any form of attempt by personal service, meaning someone hands it to you. If there's going to be personal service, the claimant themselves can't do that personal service. They can put something in the mail if they're permitted to do that under state law, but the claimant can't go out to somebody's house and serve. The document has to be somebody else, 18 years of age, who fills out the form and swears that they made service on this particular person.
It's a tricky area, so definitely look at our resources, then email us if you need some further guidance.
Thank you. We have another question from Jeanette Morrow, who asked, are there any cases dismissed due to fair use?
So the way that fair use would come up in a CCB proceeding is one of two ways. Fair use may be a ground for someone to bring a claim of non-infringement. So if someone is using a work and they're accused of infringement and they believe they have a fair use, they can file a declaration of non-infringement claim with us so that the CCB would find in their favor, or ask the CCB to find in their favor. The second way that a fair use would come up if the CCB is as a defense in a contested case. And so, you know, as we saw in our earlier slide, we have 4 claims that are currently in the written testimony phase, and of those 4 claims, you know, the board has not had an opportunity to reach the determination yet. The board has released one final determination on a contested claim, and fair use was not an issue there.
Yeah, actually, it was.
Oh, it was there. Oh, I'm sorry.
Yeah. The respondent raised the fair use, but we found in that particular case there was no fair use, and we found the claimant to be liable. That case is 22-CCB-0045. The claimant was Oppenheimer. If you want to take a look, you can see kind of how we went through the 4 factors involved in fair use, if you want.
I think that's it for questions. I don't see any other questions. Monica, Whitney, Laura, thank you so much for a wonderful presentation. So informative, so helpful. We really, really appreciate it.
Thank you for having us.
Thank you.
Good to see you all.
Talk soon.
Thank you. For everyone on the call, I do want to let you know that we are going to send you a link to the recording of the session early next week. In the meantime, you can download the course materials that were shared in the event listing. That's in the chat now. So all the materials that were shared ahead of time, you can access those at the links in the chat. I also want to let everybody know that we are dedicated to the highest quality educational content possible for our creative community. And to help improve our programs, we hope that you will take an evaluation survey. It's a very short survey, less than 3 or 4 minutes, linked in the chat. If you will complete that survey, give us your feedback on this, ideas for future programs that might be of interest and importance to you, we would really appreciate it. But with that, I want to thank everyone for attending today. I want to thank the Copyright Claims Board for partnering with us on this event. And I hope you all have a great rest of your day and a great weekend ahead. Thank you.